So I have an important update for you in the Suppressor Freedom lawsuit, which aims to remove a state's ban on the purchase and possession of suppressors. So let's talk about this. But real quick before we jump into this video, if you think suppressor bans are clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are huge Second Amendment supporters. If you purchase from Blackout Coffee, some of those proceeds will go directly to 2A organizations like FBC and GOA. So I highly recommend Blackout Coffee. You can purchase using the code ARMSCHOLAR and you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be discussing a lawsuit which aims to remove a state ban on the purchase and possession of suppressors. These are two essentially consolidated cases. It's the Morse v. Raoul case and then the Anderson v. Raoul case, but they've been consolidated together and they're moving forward to challenge the state of Illinois' ban on the purchase and possession of suppressors. This lawsuit is important because although there are 42 states which allow for the ownership of suppressors, there are 9 jurisdictions within the US which don't. These lawsuits could be the first in the nation which find that states outright banning NFA items like suppressors is in fact unconstitutional and violates the Second Amendment. However, in this case, the state of Illinois right now is trying to have the entire case completely thrown out by arguing that suppressors are not arms and therefore they are not protected by the Second Amendment. Therefore, the state of Illinois is currently requesting that the judge in this case grant a judgment on the pleadings in the state's favor and then ultimately throw the entire case out. This lawsuit is also important because it uses the Supreme Court's recent ruling in New York State Rifle and Pistol Association versus Bruin to attack a state ban on suppressor purchases and also their ownership. In Bruin, the Supreme Court issued an opinion authored by Justice Thomas, which struck down New York's May issue CCW licensing scheme, and they found that it was inconsistent with this nation's history and tradition. One of the primary findings of the Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of this nation. This lawsuit aims to finally make a state like Illinois explain how their outright ban on suppressors is in fact consistent with Heller and now Bruin, and how it's consistent with our nation's history and tradition. But now the state of Illinois has filed a motion for judgment on the pleadings. The entire motion is based on the state's argument that this case should be completely thrown out because suppressors are not arms and therefore not protected by the text of the Second Amendment. For those not aware, a motion for judgment on the pleadings is a motion made under the Federal Rules of Civil Procedure 12C. It is used to attack the sufficiency of an opponent's pleadings and the viability of their underlying claims prior to a full trial. The court, in review of the motion, is strictly limited to the contents of the party's pleadings and any documents that are attached to those pleadings. If a party wins the motion, then the claims are ultimately dismissed by the court and often can also prevent a new lawsuit on the same claims from ever being brought. So the state of Illinois is trying to get this suppressor lawsuit thrown out and prevent any future challenges to the state of Illinois' ban. Now, in their motion, the state of Illinois argues that plaintiffs raise a Second Amendment challenge to an Illinois law prohibiting the possession of silencers which are attached to firearms to reduce the noise of gunfire. But the Second Amendment protects only the right of the people to keep and bear arms. They say that silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. The state of Illinois then also goes on to argue that plaintiffs wish to possess silencers. So the question is, does the Second Amendment cover this conduct? Or more particularly, are silencers arms within the meaning of the constitutional text? Every court to address this question, they say, has held that silencers are not arms protected by the Second Amendment. They state that the reason is simple. When the Second Amendment was adopted in the late 18th century, dictionaries defined arms to mean only weapons of offense or armor of defense, or anything that a man wears for his defense, or takes into his hands and useth in wrath to cast at or strike another. They go on to claim that silencers do not satisfy this definition of arms. A silencer is a firearm accessory. It is not a weapon in itself, nor is it an armor of defense. So the state's primary argument in this lawsuit and for their motion for a judgment on the pleadings is that suppressors cannot be considered an arm under the Second Amendment because it does not actually fire a projectile and it's not actually a firearm or a weapon. They claim that only actual guns or firearms can be considered arms and therefore protected. They believe that suppressors are simply an accessory and then they can't be protected because they're an accessory. And based on all of that, they argue that this whole lawsuit should be thrown out and the court here should grant their motion for a judgment on the pleadings. Well, the plaintiffs in this case have now responded to this request for a motion for judgment on the pleadings. And in their response, the plaintiffs state that the state's terse interpretation of the Second Amendment runs contrary to the existing precedent and how constitutional rights are typically interpreted. First, suppressors are firearms because Congress said they are. Second, suppressors are protected arms because they facilitate armed self-defense. However, even if this court finds otherwise, suppressors are nonetheless protected by the Second Amendment because they are firearm accessories, and firearm accessories that exist with self-defense and other protected conduct are protected by the Second Amendment. As such, defendants' motion for judgment on the pleadings is not well taken and should be denied. Then the plaintiffs go on to address the state of Illinois' arguments that suppressors are not arms because they are not necessary for self-defense. The plaintiffs argue in their response that the threshold textual inquiry does not ask what is necessary for self-defense. It asks whether a bearable instrument facilitates armed self-defense. The National Firearms Act defines firearm to include silencers, and the Gun Control Act likewise defines firearm to be any firearm muffler or firearm silencers. Under these statutes, silencers are per se arms, and this court must apply the statutory definition of silencer to be a firearm because when a statute includes an explicit definition, we must follow the definition even if it varies from the term's ordinary meaning. So here they're saying, well, the state of Illinois can't put forward this type of argument saying that silencers are not arms, they're not firearms, when we have multiple statutes that say expressly that they are. They go on to then say, in any event, suppressors are plainly things that citizens carry for use in and facilitate self-defense. Suppressors are an important part of firearms because they help to mitigate some of the negative externalities potentially caused by loud gunfire, including hearing loss and noise pollution. This is very important because it's showing the utility of suppressors, them being used, and how they are actually important for self-defense. Then the plaintiffs go on to argue that even if the court finds that suppressors are not arms, they are still protected by the Second Amendment and they're protected as firearm accessories. They actually point to the Supreme Court's decision in Miller to show that certain accessories are in fact protected. They point to things like bayonets, iron ramrods, and then other types of attachments, and the Supreme Court said that those are protected as proper accoutrements. Therefore, these plaintiffs argue here that suppressors are protected by the Second Amendment because they are accoutrements which aid and assist in the Second Amendment's protected conduct, such as self-defense, training, and hunting. And based on this and many other arguments in their briefs, the plaintiffs argue that the court here should deny the state of Illinois' request for a judgment on the pleadings. So again, this is a really interesting case. This is a really interesting position that the state of Illinois is taking. They are trying to get this case thrown out right here and now by taking the position that suppressors are not arms and therefore they are not protected under the text of the Second Amendment. But again, if we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.